Rashid Faroki. I'm the chair of the Legal Aid Committee this year. And Miguel is our vice chair. He's here for anyone who doesn't know us. Nice to see you all. Thanks for coming. Please remember to sign in for CLE credit. And we'll go ahead and get started because we're running a few minutes behind. We are so pleased to welcome representatives from the Administrative Office of the Illinois Courts, specifically Sophia Akbar, Catherine Hensley, Danielle Hirsch, Jill Roberts, and Allison Spanner. And they're here to talk to us about the recent work of the office and their updates to improve access to justice throughout the Illinois court system. So I'll let them take it away.
Thank you. Can you all hear me? I just lean. Is that okay? So thank you to Angela for inviting us. We represent the Access to Justice Division of the Administrative Office, and we staff the Illinois Supreme Court Commission on Access to Justice. And as you'll hear, we do a number of things kind of behind the scenes for the court system to make it easier for both people who can't afford lawyers, end up getting the services of blind folks, or people who are limited English proficient or otherwise vulnerable. Just one kind of housekeeping thing before we start, which may be something you all know, but it took me a while to learn and appreciate on this job. We are a non-unified state, which means that 102 counties set up their courts differently. They each have an independently elected clerk. And so while the Supreme Court sits atop all of that and setting policy, we run the risk of a lot of unfunded mandates. And so a lot of what we try to do is work with local courts to pilot and improve systems. And so there's a lot, you're going to hear a lot of local state collaboration that makes this work possible. Okay, so you don't even need my slides. Okay. So our division was founded, the Commission on Access to Justice was founded in 2012 by then Chief Justice Kilbride. Okay. But let me tell you about the Administrative Office, but this is better. So the Administrative Office is the policy arm of the Supreme Court. We do everything from assist with 7-Eleven licenses, to payroll for all the judges in the state, to judicial education, to probation. Our unit is one of the newer divisions within the Administrative Office. Our mothership office is in Springfield, but we also have an office here in Chicago. And so everyone to my left or your right kind of specialize in some of the work that you see on the slides. We do everything from language access to standardized forms. We work to collect data to understand both language access and limited English proficient litigants. We develop tools, draft policies and rules, and we see what other states are doing and try to model good stuff. The division has grown a lot since 2012, so we first were able to hire Sophia, and then we hired Allison, and then Jill and Catherine this past year. Well, what the Supreme Court Commission does separate from the office is they're kind of our think tank. So our office implements a lot of work, but the commission is 11 members, 5 judges, 5 lawyers, and a circuit clerk who are designed to think about how the court system can better meet the needs of especially poor and vulnerable litigants in our civil courts. And so we have committees that are doing a lot of work, and we have a strategic plan, which the link is there, but we're going to talk about a lot. It informs all the work of our office, of our unit. So I hope you'll have the handout, but the most recent strategic plan, which the court approved in 2017, which we're operating under, has kind of 5 core principles that all of our work falls under, which are plain language, process simplification, procedural fairness, equal access, and continuous improvement. And then all of the issues that do fall within those. So by plain language, we mean language that's in a simplified form as possible so that users understand what needs to happen. So a really great example of that, which was a partnership with the Chicago Bar, was the change from forcible detainer to eviction, trying to get people to understand what's happening to them. And another one is process simplification. So we have a court system that's developed by 4 lawyers, but we have growing numbers of people that aren't lawyers, and so how do we meet people where they actually are and encourage systems that do that. Procedural fairness.
Sorry, can you read the mic a little closer?
Oh, sure. Sorry. Procedural fairness, I guess what we mean by that is that everyone feels heard in the process and that the system, regardless of the result, engages the users. By equal access, we mean everybody has a chance to come to court, and that we're constant and improvement, that we are constantly iterating and doing better. So here are, I won't read all of them, but these are our 10 initiatives. So everything from forms to community trust, and we're going to spend time going through each of them. I just wanted to show you, for those who haven't seen us talk before, over the past 3 years, we've been trying to get a handle on the numbers of self-represented litigants that come to our courts, but we're also trying to get a sense of what our civil courts now look like. And I think the most interesting thing, and this bears nationally, there was a large national center for state courts report last year that bears the status significantly. But an overwhelming majority of our cases are now debt collection or cases seeking usually about $10,000 or less money judgments. So when we think of the civil court system, at least the judges, and when we talk about it, we often think of the really complicated commercial cases, but that's like 2% of the overall docket. Torts is even less. So the work that you all practice in is really a huge part of our court system, which will be no surprise to you, and about 25% of our civil cases are family cases. And then as far as self-represented litigants, Jill will get into this a lot more, but our court system is changing. The user base has changed materially, and so now we're trying to help all those stakeholders better meet those new needs. And so Jill has been working to try to figure out our landscape, and you can see just the numbers. At least 150,000 cases that involved self-represented litigants last year, and you can see by case whether dependent or plaintiff starting. The majority of cases have listed that have a self-represented litigant have a defendant who's a self-represented litigant. And then for language access, we're hindered by data that's a little bit flawed as we can get into this, but we only keep data on the number of interpretations provided by courts. So if somebody comes to court and needs an interpreter for whatever reason is given one, we don't have that in the count. So our number is severely undercounted. As you can see, the past few years, it's covered between like 170 and 180,000 instances of communications in court, and the majority of those are criminal and traffic. And the Supreme Court has a policy, as well as federal law, that requires interpreters in all kinds of proceedings. So what Sophia talked about is how we're trying to make that a reality. With that, I will turn it over to Allison.
Thank you, Danielle. My name is Allison Spanner, and what we're going to spend the rest of our presentation on is going through the Commission's 10 initiatives. So initiative number 1 is to develop, automate, and translate standardized plain language legal forms. And this was one of the first initiatives, including language access, to come out of the inception of the Commission. And so this has been going on since 2012. And we are pleased and proud to announce that we have over 25 form suites that allow self-represented litigants to access the courts. As we all know, it's paper-based, and without the ability to write a motion or to petition or to defend themselves in any other way without any other guidance, it's very challenging to participate in our court system. So these forms work to solve that problem. They are written in plain language, and we use plain language to move ahead here. To not only explain how to fill out the form, but to describe a legal process. So our forms are kind of distinctive. If you've seen them, you would be able to recognize them. They have instructions down the left-hand side that explain to somebody how to fill out the form. But we also have, in every form suite or form packet, we have a getting started, which allows someone to kind of initially determine whether they qualify for using this type of form. And then we also have a getting started that talks about how to e-file or ask for an exemption. or how to serve the other party, how to prepare for your court date, whatever's relevant. And so the Forms Committee has 8 active subcommittees drafting forms in a variety of areas of law, and they're all, the work of the forms are developed by volunteers who are subject matter experts in that area of law. And while attorneys would be prohibited from using our forms, they are drafted specifically for self-represented litigants. But if they meet your needs, there's no reason that you can't use them. And I have a handout here that has all of the forms that have been developed in what areas of law. So we have appellate, divorce, eviction, expungement and sealing, mortgage foreclosure, name change, post-judgment, procedural forms, and Supreme Court forms. I also have a list on the back of forms that are in development. So we have just as many in development as we have published right now, so I expect really exciting advancements and broadening of this project even in the next couple of years. So this is the process for development form. It's very laborious and very conscious of review period. So we have a drafting period, and then we do a user testing period where I take them to non-lawyers and ask them to fill it out. And then we do a forms committee review, and then one of the things I wanted to highlight is the public comment. So this is one place that I ask for all of your help. We post them on our website. This is per rule, the Supreme Court's website, for 45 days, and we ask you, the experts in many different areas of law, to read them, to look at them not only from a design perspective, we think that they would be utilized from people that you either provided brief services for or represented, and also to ensure that they're legally sufficient. There's nothing that we haven't forgotten, because the committees can only imagine so many different scenarios and how these forms might be used. We really need everyone in this room to take a look at them for us as well. And so then I'll briefly plug that we currently, as of this morning, have new appellate forms posted for public comment on our website, and there's a link to it on the back of this resources for Access to Justice standardized forms page.
So the next initiative talks about using court-based navigators or facilitators in a variety of different ways. And so I'm going to talk about one of our major programs, and Catherine is going to talk about another. So last year we launched a brand new program that is called the Self-Represented Litigant Coordinators. And this was a project that was modeled after a program in Colorado where they actually have one of these coordinators in every single one of their judicial circuits, which to me is the dream. But for right now, we just have 1 year under our belt, and we had 9 circuits that received grant funds, and then we have an additional 4 circuits that did not receive funds but wanted to be part of the network. And so it's a group of people that currently work at courthouses around the state to look at what their specific locality needs as far as helping self-represented litigants. So we have quite a wide variety of types of projects. But what everyone is doing is trying to figure out what are the program needs, where we are, what can we do to develop new resources, and how can we best get everybody in the courthouse on the same page and give good resources to self-represented litigants. So it's been a really great first year, and Cook County is one of the recipients for this year, specifically their Domestic Relations Division. And so I don't know if any of you have seen anything that they've done. They've been doing a lot of resource packets for judges so that every judge in the division has information to give out to self-represented litigants in their courtrooms to just help spread the information for self-represented litigants.
Hi everyone, I'm Catherine Hensley. In addition to what Jill just mentioned, we also help run a program which is a very unique collaboration with the Chicago Bar Foundation and the Illinois Bar Foundation. It's an AmeriCorps program called Justice Corps. And essentially what Justice Corps is, it provides volunteers who generally commit to a year of service in our courthouses to make our courthouses more welcoming and friendly for court patrons, whether they be self-represented litigants or anyone needing information. Depending on the courthouse culture, our volunteers do myriad things in the courthouse, anywhere from or assisting with e-filing to helping patrons find appropriate forms and providing navigational assistance to people entering courthouses. Really excited about this partnership. We are in 13 courthouses across the state. We're in every appellate district. And we are really looking forward to continuing the program and helping it to grow and to develop. This year we have about approximately 48 volunteers committing to a term of service in our courthouses throughout the state. So our third initiative is evaluating self-help services. We're going to just briefly speak a little bit about some of the exciting initiatives that we have underway. The first is this coming year, the Supreme Court will be launching a new website with the goal of making content easier to access for court patrons, and also obviously providing more content through the Access to Justice Initiative. In addition, our department has been developing process maps to assist SRLs. And as everyone understands, there's obviously a multitude of ways to communicate legal information to people. We're really trying to simplify that process and provide as many avenues in terms of providing this information as possible. The first process map, which will soon be released and which I believe Danielle will be speaking about a little later, is a divorce with kids overview. So these are just really visual aids to assist people and to give kind of a snapshot of the legal process. In addition, and this is modeled after what the Chicago Bar Foundation was doing at the Daly Center and at Markham. Staff of the Justice Court have developed what we call prescription pads, but essentially they're 1 to 2 page documents that serve as legal referral sheets. They provide information about social service organizations as well as free legal aid organizations that are local in that courthouse. We're really excited about developing these in each of our 13 Justice Court courthouses because it's just something tangible that when a court patron comes to a self-help center, they're able to take away with them. We also intend to, once they are finalized at all of our sites, publish those online through the Illinois Bar Foundation's website. So we'll be certain to notify you once those are available. But again, they're just additional aids to help people. And then finally, in terms of self-help content, the Supreme Court, as of April 1st, approved a policy on plain language. That policy is obviously available on the Supreme Court's website. And it essentially aims to help the public understand important legal rights and concepts, as well as to make informed decisions about their respective case. It provides guidance to judges, court staff, law librarians, and other court partners in terms of providing plain language. And I believe later this year, or early into next year, there will be standards published on the Supreme Court's website, including a glossary to assist people in using plain language to assist or better assist court patrons. And then, in addition, one of the other projects that I work on involves a fairly new initiative with the AOIC, and it is a program aimed at providing self-help materials in civil appeals. We recently published, or updated rather, the AOIC's appellate guide to include information about e-filing in each of the appellate courts. We're also creating a number of other materials and designing other initiatives. That includes, I'm very excited about this, is providing a workshop series aimed at helping people understand the civil appeals process. That will be a multi-part workshop. The first in that workshop will most likely be aimed at what is or isn't an appeal, what that includes, what it entails. And the second part is to help people understand how to conduct legal research and assistance with brief writing, again, aimed at SRLs. We also are and will soon be publishing e-filing guides. So Jill has published a number of e-filing guides aimed at circuit courts. We're just waiting for final approval, but we will be publishing those on our website in the near future to assist SRLs with that process. We also are developing a comprehensive FAQ section, which once the new Supreme Court's website is launched, we'll have a dedicated page for self-help for civil appeals, and that FAQ section will be quite detailed and comprehensive. Going back to what I said earlier, just about providing overviews and snapshots and process maps, we're also looking at appeals and creating materials for appeals in that sense, and providing just really bird's eye view of like the steps involved in a civil appeal, and providing other aids to help people understand a very detailed and complicated process. And then the final thing at the moment that we are working on is we hope to initiate a pilot project in the First Appellate District, which will encompass assisting SRLs as they file their civil appeal and helping them navigate the process and really pushing a lot of self-help materials toward them and conducting a lot of one-on-one follow-up with litigants to ensure that they're able to complete the process, as well as understanding barriers to why they may or may not complete their appeal.
Okay, so next we're going to talk about remote access. And by that we really mean remote appearances. This is one area where the Supreme Court actually has had for a number of years really progressive Supreme Court rules that allow litigants and lawyers to appear remotely. And there's specifically Supreme Court Rules 185 and 241. But they're not used very much. And so part of what we're working on is a draft Supreme Court policy that, for the Supreme Court to review that would encourage local jurisdictions to make this more available. And part of it too is trying to figure out, there is a company called Court Call, I don't know how many of you have heard of it. It's primarily used in the collar counties to allow lawyers to participate remotely, but it charges a fee depending on the jurisdiction at $60 to $80 per appearance, and fee waivers are not honored. So we're trying to figure out an end run around Court Call to make it affordable. And so we're trying a number of pilot programs in different jurisdictions across the state. So one example is here in Cook County, we're trying a mortgage foreclosure pilot program where status appointments could be done via video. And so we're working with a handful of judges to try a pilot in that space. In the 15th Judicial Circuit, which is kind of the northwest corner of the state, we're going to try it with emergency orders of protection remotely from a domestic violence shelter. And then in Yorkville, which is near NIU, we're trying just a general civil call and allowing people the option to participate remotely. And then another initiative is process simplification. Sorry, I can't do two things at once. For this one, the big thing that we're working on right now is there's a really cool program in Alaska, I don't know how many of you have heard of it, where the Alaska courts took family law cases and set the first call if both parties are self-represented, and gives them access to either a mediator or each get pro bono counsel for 1 3-hour opportunity to try to solve the case, to resolve the case amicably that day. So one day, solve the case. We are trying much smaller versions of this concept. The first one we started was in McHenry County, which is Woodstock. If you ever saw Groundhog Day, it's where it was filmed. We started there a program with Prairie State and the local court there, where if a case is double pro se and there are no children involved, they get invited to participate on a special call on the third Thursday of the month, where a legal aid lawyer is there, and both parties can come, and with paperwork, the legal aid lawyer will review it for completion, and if they have an agreement of minds, they prove up that day. And so cases are going through the entire process in 6 days sometimes. So if you file close to that day, you can really be done. It's a way to make joint and simplify broader, and it allows people really quick access, whereas otherwise it was taking about 8 months for that same case to go through the process. With the great work of Samira and Chicago Bar, we're trying a much more ambitious pilot, or different pilot in Cook County, where any case where both sides are self-represented, starting this month, is actually being sent to meet a hearing officer who's going to triage the case and give them resources and either set future meetings with a hearing officer, set them for kind of the equivalent of the Alaska pro bono model, or send them back to their regular calendar. So it's a way to kind of triage cases and see what kinds of cases are coming and how we can best expedite them. But again, this is totally new and yet untested. So, and then this is the flow chart that Catherine mentioned. So this has taken us an embarrassingly long period of time to put together, and we'd be happy to take her feedback before we finalize. But as you'll see from Jill in a minute, we've interviewed a number of self-represented litigants about the experience of being self-represented. And an overarching theme that people have had is that the legal process is really opaque, and that you don't have a sense of all the steps in a particular process. And when we give you just a handful of forms, the forms are really great, but they don't give you a sense of how long the process might take, and whether you really do need a lawyer or you do it on your own. And so what we tend to do is kind of roll these out in a whole bunch of different topic areas that judges can use on the bench, that clerks can use, and that we hope advocates can use, just letting people kind of get a very bird's eye view sense of the process. So yeah.
All right, so the next two initiatives focus on training. One initiative focuses on judges and one on court staff. And so we approach both of these groups of people in a couple different ways. But what we hear from them is that both judges and clerks say that having self-represented litigants involved in the court system makes their job harder. And so we want to figure out how we can make their jobs easier while also serving self-represented litigants, and that's how it'll make judges and court staff's jobs easier. So for judges, we provide resources and training in a variety of different ways. So one major way is through the Judicial Education Conference, referred to as EdCon. I'm sure most of you know that terminology. So that happened this year in February and in April, and we had a variety of sessions where we talked about self-represented litigants, from poverty simulation to dealing with language access, remote appearances, limited scope, which is an area that you can be involved in quite a bit by providing limited scope services. So maybe you're not doing a full case, but the people will be going self-represented for part of their case. It still can improve their experience as well. In one session we did in particular focused entirely on self-represented litigants. We talked about Rule 63, which requires judges to make reasonable efforts to facilitate the ability for self-represented litigants to be heard. And so there was a lot of really great discussion among the judges about what does that mean. It is a pretty vague rule, but what can we do to provide guidance to them? So we put together 10 tips for making sure that SRLs can be fairly heard. And one thing we did at that session was provide videos of self-represented litigants themselves talking about their experience. So we're going to show you one of those if we can.
Is it capturing?
It is not.
Throughout this whole process, I kind of stumbled in the dark because I think the biggest challenge for me was not knowing, like, if I'm going to make a cup of coffee, I have to grind the coffee, put the grounds in the coffee pot. I know the steps to get to the coffee. Here I didn't know the steps. I didn't even know what I didn't know. It's scary, having to go before the judge and explain to them that I wasn't going pro se, that I couldn't afford an attorney. It was very scary the first time I had to go before the judge.
Part of my concern or my frustration with this is that I am technically an attorney. I went to law school, I passed the bar, I actually practiced law for a couple years, but in intellectual property. I never came near litigation in my life. I don't even watch TV court shows, and I realized that actually would have been really helpful to me. I feel like walking into a strange church. You know you're in a church, you know there's going to be rites and rituals, but you really don't know what the heck they are, and you know you're not one of them.
So we did a whole series of those, and the judges were really receptive to hearing from the self-represented litigants' voices. So on all of your tables, there are some flyers. We want to do more of these videos. So if you want to post these flyers or tell people about this project, if they've gone to court at all by themselves, so even if they are now your client, but they previously have gone to court without you, or if you're doing maybe document preparation and they're going to court by themselves, we would, if they're interested in participating in this video project, we would like to hear from them so that we can make more of these videos. In addition to training judges with those videos, we are hoping to present them at a national conference that's going to be taking place in Chicago in April, which you'll hear more about from us later. It's through the Self-Represented Litigation Network, known as SRLN. Like I said, you'll get more information, but we're trying to put together a new compilation of videos for that conference as well. The last thing about judges for training is that we do a monthly column in the Illinois Courts Connect newsletter, which goes out to all the judges in the state, and we do an access to justice topic each time, usually centered around self-represented litigants. But if you have ideas of what you think judges need reminding of, or things that come up or situations that you see, let me know, and we'll make sure to get them on the list of topics for our Justice Corner. And then for training court staff, we focus primarily on circuit clerks, since they are the kind of gatekeepers to the court. And we train primarily on the line between legal information and legal advice, which is outlined in the court's policy on assistance to court patrons, which we call the safe harbor policy. We did a lot of training this year on e-filing from the user perspective. So the clerks, of course, have all sorts of things going on behind the scenes that they need to do with e-filing, and it turned out that most of them didn't really know a lot about the front end of e-filing and what it looks like to be a filer and to get through that process. And then we give some training on things like customer service as well.
All right, my name is Sophia, and I am responsible for the language access program for our division.
I need you to move the mic.
Oh, okay. Oh, it's on. Is that better? Is better? All right, so prior to my hiring, there was no statewide standards for language access. There was a criminal proceeding interpreter act that required interpreters in criminal cases, but there was nothing on the civil side, and that was very incongruent with federal law. So with the APA, sign language interpreters are required for not only parties but also spectators in the courthouse. And for spoken language interpreter needs, Title VI is the federal authority, the non-discrimination clause of Title VI. It requires that state courts provide interpreters in both civil and criminal cases. So one of the first things that we did was create a Supreme Court language access policy that made the state policy consistent with federal law. And there is now a statute in the Illinois Code of Civil Procedure that also makes it clear that interpreters are provided in civil cases. That being said, the picture is very different depending on where you are in the state. The main reason for that is that interpreter services are funded at the local level, so it depends on the resources that are available to that county and their level of commitment to language access. So just to kind of clarify, the language access policy requires that interpreters are provided for parties and witnesses in both civil and criminal proceedings, and we also require it for court annex proceedings, which includes probation, contacts, mediation, arbitration, also anything that's court-ordered. So that could be a court-ordered medical evaluation as well. The court is required to provide those services. In Cook County, they prioritize criminal cases first, and then civil cases have a priority as well. So I wouldn't be surprised if a lot of you have reported that you had to go to court and either make arrangements for an interpreter yourself, or your client had to, and that's just something that we are trying to work on. Luckily, the picture is kind of getting better in other parts of the state. More and more courts are understanding that it is their responsibility to provide interpreters in civil cases. So I just wanted to kind of briefly touch on the different services and resources that we provide to courts to assist with providing language access. We have created multilingual notices in the top 6 languages of the state to provide notice to people who are coming to court that the court is required to provide an interpreter for them. We also translate the forms, as Allison mentioned. Some of them are translated in our top 6 languages, and some are just in Spanish and Polish. And we also have some translated website content. We manage an interpreter registry, so we have a certification program that's modeled off of the National Center for State Courts, and all states that certify interpreters, we all use the same exams and have roughly the same program models. And that registry is available on our website. Those interpreters can be used, remotely over the phone as well. And a lot of, I've been contacted by a number of attorneys that want to use interpreters on the registry to prepare for court. We also try to incentivize the use of registered and qualified and certified interpreters through reimbursement. So we reimburse local courts when they use certified interpreters. And thankfully, we've seen a change in behavior since starting the program. So when we first started offering reimbursement, I would say about 25% of courts were using interpreters on the registry, and now that number has increased to about 50%. So still a long ways to go, but it's at least moving in the right direction. We also have identified a cheaper contract for telephonic interpreting services, and we advise courts only to use it for non-court communications and over-the-counter communications, but there are still some courts that use language line for court proceedings, which is not great. I'm sure some of you have experience with language line, a lot of issues. But we at least try to encourage court offices to have that available. Another form that we have translated is an interpreter request form. I would encourage all of you to make use of that form and file it with the court. As I think the more that the system can kind of change the expectations and put the onus on the court to provide interpreters. Another program that I'm working on is a video remote interpreting pilot in 5 counties, or 6 counties in the state. And these are counties that have some rare language interpreter needs. They have a lot of difficulty getting in-person interpreters. And so this would both increase their access to rare language interpreters and qualified interpreters that are not necessarily in Illinois, but across the country. And finally, I just wanted to point out the link to our registry. It's at publicapps.illinoiscourts.gov, and you can search the registry by which circuit they're willing to travel to, their language.
So Initiative number 9 is to identify, develop, and promote the implementation of court policies and rules that promote legal representation, including limited scope representation. And one way that we've done that, I mentioned briefly with EdCon, we had a standalone session this year specifically about limited scope, and a bench card was created that all judges in Illinois were provided with that just gives judges tips on how to be more familiar with the limited scope rules. We've been hearing from attorneys that sometimes judges weren't letting them out of cases, even though they had finished their limited scope and things like that. So it was turning them off to doing further limited scope work. And so we reached out to judges to say, hey, this is a really great set of rules and it can provide access to a lot of people to a variety of types of legal services as long as everyone's on the same page. And through the ABA report that they did last year, the survey of the entire state of Illinois, the number one answer for how or what would have attorneys do more pro bono work was to have more limited scope opportunities. So the more that your agencies can set up maybe limited scope opportunities for firm partners or whatever it might be, or your agencies yourselves providing limited scope, that is certainly a way to kind of open the doors to people who may not be able to have lawyers for their entire case, but they get a little bit of assistance that can go a long way.
Okay, so the newest initiative of the commission is community trust. The main goal is to try to improve community awareness of all the great work that you all do and also the services that are provided in the courts. And another main goal is to listen and to learn from the community about their experience navigating the court system. And eventually we would like to put together a report and make recommendations to the commission report for changes based on what we've learned. So we had our first one this week. It was on Tuesday, and we're focusing on the south suburbs of the county. We've been attending local meetings with mostly social service providers to try to build relationships. And the meeting on Tuesday was primarily focused around mental health. And we have another one scheduled on October 24th. There are flyers on everyone's table. And then we have another one at the Markham Courthouse on November 1st. So at each one we have a panel of judges and legal service providers, many of your colleagues, sharing information about what services are available, and then the majority of the time is spent talking with the community and learning about their experiences and challenges. We're really excited about this opportunity, and hope that our experience here will provide a good model for making recommendations statewide.
So with that, we'd really love to hear from you and have a dialogue in the remaining time. I guess the one thing that is not one of our 10 initiatives that I wanted to mention is that our division recently had a name change. We went from the Civil Justice Division to the Access to Justice Division, which was a long time coming, but part of the impetus for the name change is the Constitution, the Illinois Constitution requires that the judicial branch have a judicial conference. It's kind of like the board of managers for the court. And this year, the Chief Justice has changed the format of that body. It's now going to be a 29-person body that's 15 judges and 14 non-judges. And our division is going to staff that new body, which is going to provide strategic planning for the branch as a whole going forward. So we don't know a whole bunch more than that. It kicks off in November, but it's an exciting opportunity for us to try to shape the direction of the court system. And with that, we'd really love to talk to all of you. Yeah.
Regarding your development of self-help content and appellate resources, what kind of collaboration are you partnering with Illinois legally online in terms of the development of that content and sharing with the community?
Yes, I am give a huge shout out to Illinois Legal Aid Online. They have been an amazing partner since the inception of the statewide standardized
We have one staff person that sits on every single one of our subcommittees and provides plain language guidance to that, and we really could not do what we do without Illinois Legal Aid. And they also post and automate our forms as well. And we just recently, we were always looking at ways we can repurpose content. We excluded a particular type of form that we wanted to do in eviction because we felt it was too complicated, and we are now handing it over to Aleo to post it on their website, repurpose that information. So we couldn't do this without partners. And I don't know if anyone else has anything to add, but
A lot of our resources are posted to Aleo, so when we came out with the e-filing guides for the circuit courts and the couple of updates that we've done to them since, we always provided them to Aleo for posting, as well as the updated appellate guide that Catherine just finalized. So, yeah, we work closely with Aleo.
What happens, you take into accessibility of teachability.
Yeah, so we work with the Illinois Deaf and Hard of Hearing Commission to train sign language interpreters, and on our registry we have about 150 sign language interpreters. So, you know, so the IDHC has a licensure system for sign language interpreters, and we invite them to trainings in order to get comfortable providing services in court. And then we also reimburse for their services. And we also provide assistive listening devices to courts and simultaneous interpreting equipment, which can help some deaf and hard of hearing individuals.
I guess there is not within our unit, but there is also someone who's in charge of all the court disability coordinators in each circuit, or each county has one. Excuse me, and so there's a relationship with the Attorney General's office for each of those folks to be trained. And so there is someone who isn't us who is a more direct conduit to those court disability coordinators. Our piece is really more as it relates to ASL.
And one final thing, all of our forms that are posted, are published on the website, have are ensured that they are ADA accessible for screen readers. And for more complicated resources like the e-filing guides, the company that we use to, we just got them translated into Spanish, so those will be coming out shortly, so stay tuned. We also ensured that those were ADA accessible and had the appropriate alt text for all of the screenshots and images that we used in those e-filing guides. So all of those updated English version that are ADA accessible, as well as the Spanish version, will be coming out very shortly.
Thanks, Sylvia. I didn't understand what the simultaneous interpreting equipment, what equipment is that?
That is essentially a headset that both the interpreter and the LEP litigant wear. So the interpreter speaks directly into a microphone, and it's primarily to limit noise interference in the courts when the interpreter is interpreting what the attorneys are saying, what the judges are saying. And some courts have used that for certain deaf and hard of hearing individuals, or I should say that, certain hard of hearing individuals who can wear it and turn up the volume, and that can serve as an assistive listening device for certain individuals.
Are there any new justice court sites that people should be aware of that are on?
Absolutely, I think it was remiss in not mentioning that this year we opened 3 new locations in McHenry County, Kane County, and an additional site here in Cook County at 26 and Cal, which is our first kind of exclusive foray to criminal court buildings. So we're very excited about the expansion of justice court. We have a lot of interest from other courthouses statewide on getting the program in their local districts.
Well, if you have other questions, mean, unless you have questions, but we could afford you today, I guess. But thank you for the opportunity. It's a real pleasure to be here with all of you and, partner with all many things. Thank you.
We'll take suggestions too, not just questions. If we've missed big things that you think we should be working on, let us know, and we'll see what we can do.
Well, thanks so much to all of our speakers.